Okay, let's unpack this. Imagine Alex and Jordan. For 2.5 years, right? Well, this guy, Mr. Whitby, he's been abroad.
Mm-hmm.
They've been openly using his sort of neglected back porch and garden.
Okay.
Like, we're talking morning coffee out there, they're mowing his lawn, they even repainted the railing.
Wow. Okay. Getting quite comfortable.
Yeah, storing their bikes in his shed, and even jokingly posting on social media, our second home. Sounds like they've really settled in, doesn't it?
They certainly sound like it. But, here's the twist. Mr. Whitby has just come back.
Ah.
And he is not happy. He's talking lawyers, legal action.
And here's where it gets, really interesting. Alex and Jordan, they're genuinely arguing that because they used it openly, continuously, exclusively, all that stuff, for this time, they might actually get to keep it.
Through adverse possession, or what people often call squatters' rights.
Exactly. Is it really that simple, though? Just set up shop on someone's land and, call it your own. We are about to find out.
Yeah, let's dig in.
This deep dive is all about cutting through those myths around adverse possession. We're going to pull out the key bits from the legal sources you brought.
Right.
And apply it straight to Alex and Jordan. It's kind of your shortcut to actually knowing what's what on a topic that, let's be honest, is often totally misunderstood.
And there are some surprising facts in here, definitely.
Yeah, we're not just listing timeframes. We're going to see how, property rights really connect to a country's history. Like, is it about using land or making sure ownership is crystal clear?
It's fascinating how different places land on that.
Totally. So to understand what Alex and Jordan are facing, first, what is adverse possession, really? Because it sounds like it's tougher than just, hanging out somewhere.
Oh, much tougher. Most places have these fundamental requirements. You generally need possession that is, first, open, so not secret, visible.
Like the social media posts, maybe?
Exactly. Visible to the owner if they were looking. Second, it's got to be continuous, not just popping in now and then.
So if Mr. Whitby came back for a week and they left, the clock resets.
Pretty much, yeah. That continuity is broken. Third, it needs to be exclusive, meaning the claimant is using it like an owner would, excluding others, including the actual owner.
Okay.
Fourth, it has to be hostile or adverse. And this is key. It means without the owner's permission.
Ah, so you can't be squatting if the owner said, yeah, go ahead, mow the lawn.
Precisely. Permission kills a hostile claim. And finally, and this is the big one we'll be talking about, all this has to happen for a specific length of time, the statutory period.
Okay, so those 5 things: open, continuous, exclusive, hostile, and for that set time. That's the foundation.
That's a bedrock, yes.
Now, what's kind of wild is how that statutory period, that time requirement, changes so much depending on where you are. It's a real patchwork globally, isn't it? Reflecting those different ideas about land.
Absolutely. Let's take a bit of a tour. How about we start with the UK, specifically England and Wales. It's got an interesting setup.
Okay, UK first.
So, in England and Wales, if it's unregistered land, which is getting rarer now, you typically need 12 years.
12 years.
12 years of factual possession, plus you have to show animus possidendi.
Animus possidendi. What's that?
It basically means the intention to possess. You're not just using it, you're acting like you intend to be the owner, making improvements, maybe trying to keep others out.
Got it. More than just coffee on the porch.
Definitely. But most land now is registered. And for registered land, the rules changed quite a bit with the Land Registration Act of 2002.
How so?
You can apply after 10 years of adverse possession. 10 years. But, and this is crucial, the actual registered landowner gets notified when you apply.
They get notified. You mean like they get a letter saying someone's trying to claim their land?
Essentially, yes. The land registry tells them, and this is a massive hurdle. It really shows that modern UK law prioritizes protecting the registered owner. That old use it or lose it idea. Less important now for registered titles.
Wow. So the owner gets told and can just say, no.
Pretty much. They have a strong right to object, and unless they just ignore the notice or there are some very specific boundary exceptions, the claim usually fails. It makes successful claims on registered land very, very difficult.
So sending a warning letter to the person you're trying to take land from?
Yeah.
Yeah, that definitely stacks the deck in the owner's favor. Makes it almost impossible then.
For registered land, generally, yes.
Yeah.
It's designed that way. A real shift in philosophy.
Okay, that's a huge deal. So the UK has this complex system, especially with notification. What about across the pond in North America? Let's head to Canada.
Canada is also provincial, so rules vary. In places like Ontario, Alberta, Quebec, the general rule is 10 years.
10 years. Similar to the UK's registered land initial period, but maybe without the notification part being quite so central.
Generally, the notification process isn't the same automatic block as in the UK system, but you still need that decade of open, continuous, exclusive, hostile possession. And Ontario, interestingly, is actually tightening its rules, making claims harder.
So a similar trend towards protecting owners.
Seems like it, yeah. But then you get British Columbia. BC is a major outlier.
How's that?
In BC, they effectively abolished adverse possession for any claims that started after 1975.
Abolished. Like
Yeah.
completely for modern claims. That's huge.
It is. It means if your adverse possession started after that date, the doctrine just doesn't apply. You can't make a claim based on it.
So that's ultimate landowner protection then. No squatter can take your land there, basically, if the squatting started recently.
For claims arising post-1975, yes. It's a very clear statement favoring secure, registered titles above all else. Now, if your claim somehow started before 1975 and you met the old rules, like 20 years for private land, 60 for crown land, that's different. But for anything recent, no dice in BC.
Wow. So from a system maybe meant to keep land used to one that just locks down existing titles. That's fascinating. Okay, down south to the United States, that's always a patchwork, right?
Absolutely. The U.S. is all over the place. The time needed can range anywhere from, say, 5 years in some states to 20 years or even more in others.
5 to 20 years, that's a big range.
It is. And it can get even more complicated. Some states look at whether the person occupying the land did so in good faith or bad faith.
Good faith or bad faith? How does that work?
Well, good faith might mean you genuinely, but mistakenly, believed you owned the land, maybe because of a dodgy deed or a survey error. Some states might require a shorter time period then.
Okay.
Bad faith means you knew full well you were trespassing. Some states don't care about your intent. Others might actually require a longer period if you knew you didn't have a right to be there.
Huh. So your state of mind could actually change how long you need to be there.
In some U.S. states, yes. It adds another layer of complexity.
Right. Okay, let's fly across the Pacific. What about Australia?
Australia, again, varies by state and territory. For private land, you're often looking at 12 years. That's the case in New South Wales, Queensland, Western Australia, Tasmania.
12 years seems common then.
It is, but Victoria and South Australia require a bit longer, 15 years.
15. Okay.
And Crown land, government land, is often treated differently. Either adverse possession doesn't apply at all, or the time periods are much, much longer, like 30 or even 60 years.
Right, protecting public land makes sense.
And then, similar to BC and Canada, you have places in Australia where the whole idea just doesn't apply anymore for new claims, specifically the Northern Territory and the ACT, the Australian Capital Territory.
So abolished there too, you just can't make an adverse possession claim in those territories.
For new claims, basically, yes, the legal route isn't available there.
Wow. Okay, so we've seen this huge range. Tough UK notification systems, outright abolition in places like BC, NT, ACT, and then these varying time frames, sometimes even depending on intent in the US.
Exactly. It really highlights how different legal systems balance things, doesn't it? That historical idea of, encouraging land use versus the modern push for really secure, clear ownership.
Yeah, and the trend in many places seems to be leaning towards protecting that clear title, especially for registered land.
That definitely seems to be the direction in several key jurisdictions like England and Wales, and the reforms in Ontario point that way too. Abolition in BC, NT, ACT is the strongest form of that.
It makes you think, doesn't it? These dry legal rules are actually about core ideas of what it means to own something in different societies.
Absolutely. It impacts how you think about your own property, potentially what you need to do to protect it, depending on where you live.
Totally. Okay, so let's bring this all back home to Alex and Jordan, our hypothetical porch sitters. After hearing all this, 2.5 years, how does that stack up? My gut feeling is not good.
Yeah, your gut feeling is spot on. Unfortunately for Alex and Jordan, 2.5 years is just, it's nowhere near enough anywhere we've looked.
Gotta break it down. In the UK.
Far too short. They need 12 years for unregistered or 10 years for registered, plus they'd have to survive that notification process we talked about.
Which is super tough. Okay, Canada.
Again, way too short for Ontario, Alberta, Quebec, those need 10 years. And in British Columbia, No claim possible anyway, since it clearly started after 1975.
Right, abolition rules them out there. The U.S. with that 5 to 20-year range.
Still not enough. 2.5 years doesn't even meet the shortest common requirement of 5 years, let alone the more typical 10, 15, or 20. Even good faith wouldn't help them bridge that gap.
Okay. And finally, Australia.
Nope. They're well short of the 12 or 15 years needed in the states where it's possible, and in the Northern Territory, or the ACT. As we said, the doctrine doesn't apply for new claims, so zero chance there either.
So what does this all mean for Alex and Jordan? It sounds pretty final. No quirky loophole for them.
It's unequivocally clear, based on these common legal frameworks. In all the places we've looked at, Alex and Jordan are nowhere close. 2.5 years is just a tiny fraction of the time required.
Right.
That's before you even get into the other hurdles, like proving exclusive hospital possession consistently, or navigating procedures like the UK's notification system, or dealing with total abolition in places like BC or the NTACT.
So sipping coffee on Mr. Whitby's porch, joking about it online.
Yeah.
It might feel like they're making it their own space, but legally.
Legally in this scenario, based on the timelines and rules across these major jurisdictions, they have zero chance. Absolutely zero.
They'd need a time machine, basically, to even get started on the clock in most places.
Pretty much, yeah. It shows it's not some casual squatter's right you get easily. It's a very, very high legal bar.
Okay, well, this deep dive really underscores that, doesn't it? Adverse possession is complex. It's not the simple finders, keepers for land that some people maybe think it is.
Not at all.
The conditions are strict. The time periods are long and vary massively, and some places have just scrapped it all together for modern situations. It really drives home how a seemingly simple idea, legally, can be incredibly complicated and different all over the world. Hopefully you listening now have a much clearer picture cutting through those misconceptions.
And you see the why behind it too, those different philosophies about land.
Yeah. So here's something to maybe chew on after this. We've seen how fundamental ideas about property ownership differ so much just with this one concept, adverse possession. It really makes you wonder, doesn't it? What other ideas that seem straightforward, maybe about contracts or family or even free speech, might actually have wildly different legal or cultural meanings depending on where you are in the world.
That's a great point. It shows how these deep legal roots really shape everyday life and our assumptions about it in ways we might not even realize. Far beyond just who gets to use Mr. Whippy's back porch.